Hi, everybody. Thank you so much for being here. I'm Dinda Elliott. I'm the Executive Director of the Fairbanks Center for Chinese Studies. And we're so delighted to have this really important conversation, which we've been hoping to hold for actually, quite some time now. So we think we found the perfect person to talk about this. I think we've all watched in astonishment in recent years as leading Chinese entrepreneurs and government and military officials have been investigated, ousted, and disappeared, all under investigation by the secretive and all-powerful Communist Party National Supervisory Commission, the country's top anti-corruption agency. So what does the rise of the National Supervisory Commission under Xi Jinping mean for China's efforts to establish rule of law? We're so pleased today to welcome Jeremy Daum to help us answer this question in his talk titled Unchained Watchdog, How China's Supervision Commission Escapes Legal Bounds. Jeremy Daum is a leading expert on China's legal system and rule of law, and he's been watching the National Supervisory Commission very, very closely in recent years. Jeremy is a senior research scholar in law and senior fellow at the Paul Tsai China Center, was based in Beijing, hopes to be based in Beijing again, and he has more than a decade of experience working in China on collaborative legal reform projects. His principal research focus is criminal procedure law, with a particular emphasis on the protection of vulnerable populations, such as juveniles and the mentally ill in the criminal justice system. He's also an authority on China's social credit system. Jeremy is also the founder and contributing editor of the collaborative translation and commentary site called ChinaLawTranslate.com, which is dedicated to improving mutual understanding between legal professionals in China and abroad. He has written extensively about China's legal system, from the global ambitions of Chinese law to the rise of the Central Discipline Inspection Commission and National Supervisory Commission. He's spoken about all of these issues at universities throughout China and the United States, and has also co-authored a book on U.S. capital punishment jurisprudence for Chinese readers. We are equally delighted today that Bill Alford, Jerome A. and Joan L. Cohen, professor of law and director, East Asian Legal Studies program at Harvard Law School, will join us as the discussant and moderator. Professor Alford is a scholar of Chinese law and legal history, as you all well know, and he has written many books, including Prospects for the Professions in China, written with Bill Kirby and Kenneth Winston, and Taiwan and International Human Rights, A Story of Transformation, which he wrote with Jerome Cohen and Luo Changfa. Professor Alford is also founder and chair of the Harvard Law School Project on Disability, which provides pro bono services on issues of disability in China and elsewhere in Asia. So with no further ado, I'll hand it over to Jeremy, and we're so delighted to have you. Thank you, Jeremy.
Thank you so much. Thank you all so much. I'm really glad to have an opportunity to discuss this topic today as well. It's a big issue topic that I think hasn't been covered so much in the US because it's a little complicated. And it's easy to write a news report about who's missing, who disappeared, who hasn't been seen for a month. But it's hard to get into explaining the mechanism behind it. And so I'm happy to have that opportunity. I will tell you also, that introduction makes me sound very impressive. I wish I were that guy. But I will also, just to clarify where I come from in looking at this material, I'm not a proper academic. I'm not a professor on a tenure track. What I've done with my career is that I've lived in China working with practitioners and legislators in creating legal reforms. And yes, I do research as part of that, but it's largely been about legal exchange, bringing together US colleagues and Chinese colleagues and trying to be the bridge between them to explain it. I primarily have been in the area of criminal procedure and adjacent areas. And so I came across the supervision reforms when they were being introduced in 2018 from the perspective of what impact they would have on the criminal procedure. As a result, I think I missed a lot because that is a very narrow lens with which to see it. So I want to start by giving you my conclusions, because I'm told that I sometimes ramble off the rails, and I think giving you my conclusions in advance is a good place to start. The first thing I want to say is in discussing the Supervision Commission and discussing the Discipline Inspection Commission, which are one and the same in the end, it's not just about corruption. Yes, fighting corruption is a part of it, but I'm going to be explaining how that is only a piece of it. When you read media reports, you frequently see it referred to as China's top anti-graft organization, China's top anti-corruption organization. Well, it might be the top anti-corruption organization, but it's a lot more than that as well. I also will try and explain that I think it actually doesn't do a great job at making an anti-corruption effort. And if that was its sole purpose, it would be failing in that. Although China has made great anti-corruption strides under Xi Jinping with his action against corruption, this actual reform wasn't such a useful strategy. The second aspect is that this is not just a law story. I approach everything from laws and regulations because that's my training. I'm a US lawyer, and I've studied Chinese law. I read the primary materials. We translate them on the China Law Translate website. But there's more going on here. Frankly, questions that are above my pay grade normally, into the political system, which isn't what I normally study, but becomes necessary if you want to understand what's really happening here with the Discipline Inspection Committee, Supervision Committee. This is a bit of a monster of a slide, I apologize, but it's really necessary if we're going to be able to talk about what the Supervision Commission is. So this is chronological from top to bottom. First, look at the Central Commission for Discipline Inspection, the CCDI, CDIC, however people want to abbreviate it. It is established in the party charter, and its job is enforcing party discipline. Now, for a long time, it's been a big deal to separate party and state, right? Party was governed by party rules. The state is governed by law. The party rules are supposed to be stricter than the law. The idea being that party members have to lead the way, right? Or the vanguard, gotta move forward. So they were charged with this. In the administrative system, there was something called the Ministry of Supervision, sometimes called the Supervision Department, the Jianchabu, and it was charged with administrative regulatory. It would address not party violations, but violations of law that weren't crimes. Some people, I don't know if we're lawyers here, but some people get confused when I talk about illegal versus criminal. You can think of a US example as OSHA regulations, workplace safety violations. If I run an unsafe workplace, that's illegal, and I'm probably going to get a fine. It's probably not criminal unless you show something that I was willful or allowed somebody to get hurt in that way. So the Ministry of Supervision was in charge of that, and it was subject to the rules governing the administrative system, which included things of ultimately like open government information. They have to be transparent and reveal information about themselves. It was established in 1987. Actually, it was reestablished. It had existed briefly under Mao and then got shut down, as did the Ministry of Justice, etc. And then on the criminal justice side, we have the procuratorate. Now, the procuratorate is where I start because I do criminal justice. And the procuratorate is the prosecution organ, but we don't call it the prosecutor's office because it has additional functions as well. And so borrowing this term from the Soviet system, we want to make clear that it is responsible for all criminal prosecutions, but it also has legal oversight, making sure all other people are implementing the law correctly, including the courts, where they can file and reopen cases if the law was applied incorrectly. And they were responsible not only for prosecuting, but for investigating crimes of officials abusing their public power, abusing their office. So unlike most crimes where the police would investigate, for these so-called duty crimes, 职务犯罪, they would have the procurators directly involved in these cases. So the division we have is the Discipline Commission is responsible for party violations and party members, covers all party members. The Ministry of Supervision was responsible for non-party members violating administrative laws. And then if it was criminal, the procuratorate would get involved. Now, if you look at the next step down, the first major change, 1993, not too long after Tiananmen, when the country was sort of in a crisis, the Ministry of Supervision was merged in with the Discipline Inspection Commission. They became one office wearing two hats. So suddenly, not only was this office enforcing party discipline against party members, but it was also investigating non-party members who were in office. Now remember, about 80% of officials are party members. If you get up to leadership, it gets higher, into the 90s. So the Party Discipline Inspection Committee was already more powerful. But this made it even more clear that it controlled that. And just depending on who the object of the investigation was, they would have a different hat on, and they could switch back and forth. The Procuratorate was still the only organization for the criminal prosecutions, though, which meant that if after the Discipline Inspection / Ministry of Supervision completed their investigation, thought there was a crime, well, they then had to pass it to the Procuratorate to prosecute the crime. So it was a pretty inefficient system. We have administrative and party violations handled on this team, criminal handled on this, and then they introduced the 2007 under the State Council, the National Bureau of Corruption Prevention, which is responsible for policy and international cooperation on fighting corruption, etc. Now, the Procuratorate, I've worked with folks in the Procuratorate a lot. I've been lucky enough to teach classes about U.S. system to prosecutors in part of their in-service training as China is developing reforms similar or loosely inspired by the U.S. system. And so I watched this organization increasingly become professionalized over the years. These were true believers in rule of law, and they created anti-corruption bureaus around 95, mid-90s, late 90s, that were specialized for these duty crimes, going after officials who misbehaved. And they were good. And they were so good that, in fact, they were sort of outperforming the other side of the system. I'm not biased. Where they had only about 1 in 10 of their prosecutions had been handed over by the discipline inspection, and the rest were ones they initiated all by themselves. Now, there's an exception, of course, which is for everyone who's a higher echelon party leader, whether it's at the provincial, county, or national level. When it was somebody who was a leadership position, the discipline committee got first dibs. And they would make sure that it was handled as a party matter first. It might get passed on, it might not if there's a crime, but it would get passed on. Now, why does it matter who takes it? Well, not only is it a question of administrative penalties versus party penalties versus criminal penalties, their investigation power is different. The criminal justice folks have the full panoply of the criminal law. They can put people on bail, they can put people in jail, they can hold them for a long time while investigating them even. Very powerful. Gradually, though, the criminal procedure has been slowly evolving to be more just to defendants, but it's still a long way from perfect. Now, at least you get an access to an attorney now after your first interrogation. In the party side of things, the Ministry of Supervision had very minimal powers to investigate. They had to rely on assistance from others. But the Discipline Inspection Committee had great powers of investigation. including formally the power to detain starting in 1994-ish. And this was referred to notoriously as shuangui, the double provisions, the double designation, which meant they would give you the first designation, a time, second, a place that you would appear, and they would hold you for months while you investigated. Notice they only tell you when to arrive and when to appear. They don't tell you when you're going home. Shuangui was a problem, and it was extra legal. It's a party system, so it doesn't exist within the law. And obviously to the criminal procedure people, the professors and practitioners that I work with, this made it sort of an abomination. While they were trying to reform the criminal justice system, this was still out there, and it would have to often come before the procuratorate got cases to go through the formal criminal situation. So we were excited when this reform came, because we thought what was going to happen with the creation in step 3 of a National Supervision Commission was they were going to merge all these powers into a legally defined entity. And they began running pilots around 2016, including in Beijing, so I was able to see some of it and hear stories. And the idea was, they're going to let the Procuratorate, anti-corruption bureaus actually run the whole show now. And they'll be under the rule of law, and this will be great. Some people during the pilots said, well, this is unconstitutional because you have a supervision commission that's not provided by the Constitution, that's freezing people's assets, that's detaining people. So what are we going to do? Well, they amended the Constitution. And in 2018, when they amended the Constitution, we heard a lot about Xi Jinping's term limit in one of his positions, but we heard very little about the creation of the National Supervision Commission because it's complicated. It's hard to understand. They did not do what we hoped and give everything to the Procuratorate. You'll see the Procuratorate is still separate over there. What they did is they put the National Supervision Commission essentially where the Ministry of Supervision was, merged with the Discipline Inspection Committee. Again, if you go to any level, you will literally see both signs on the door. When they issue work reports, they issue them jointly. They talk about giving people sanctions. Sometimes they don't specify, were they given government sanctions or were they given party sanctions? The law and the party system were further melded. And they still don't have the power to criminally prosecute. They're still looking at violations, not crimes. So if they find a crime, they have to send it to the Procuratorate. But they decided to weaken the Procuratorate at the same time. And they did one of the largest transfers of personnel in recent history, where about 1/5 of the National Procuratorate staff was transferred to the National Supervision Commission. All of those anti-corruption bureau people. Starting at the Supreme People's Procuratorate, the highest level, about 100 people were shifted over. At all the lower levels, county, province, about 45,000 people were transferred over. So the Procuratorate lost bad. They lost a lot of their functions. They were no longer charged with investigating these crimes, but still have the responsibility to prosecute them if it gets passed over ultimately. So all of their work in professionalizing these investigators just sort of got shifted over to the new department that they had a competitive relationship with and became part of this. Now, that was probably useful to the supervision commissions because they got this expertise, this wealth of institutional knowledge, and these are legally trained people, but they're suddenly in an organization where they're very much in the party system as well as the legal system. There were a few other departments involved in anti-corruption, the auditing departments, accounting, but it's not worth quite getting into them. So, in addition to the transfer of functions and the transfer of staff, trying to unify where now both violations and crimes will be investigated by this one merged party discipline / supervision commission, they also expanded who was going to be covered by them. Remember, before it was party and non-party officials. Well, when they put out a supervision law defining the functions and implementing these constitutional changes that created the supervision commissions, they also expanded a little who was covered. It's not a massive expansion in terms of functions, but in terms of numbers of people, some people say it about doubled the number of people that were under the power of this regulatory system. It includes not only party members, but everybody who is using state power, what I would call in the US system acting under color of law, being a state actor. So it could be the head of an educational institution, the head of a meteorological association, state-owned enterprise heads who were covered by the Ministry of Supervision as well. But everybody who is using state power. The party wants to handle that first through the party system / supervision system before it gets to the criminal system. It first gets investigated here. And these specific individuals are listed in the supervision law itself and the implementation rules thereof, if you ever want to go back. Now, again, coming from a criminal perspective, thinking anti-corruption, I think, well, what do you need to fight corruption? Because I was still thinking small. And you think independence, right? You got to be independent because you're going to be going after officials. If you're dependent on those officials, how are you going to go after them? You need independence, you need dedicated personnel, you need adequate resources. The institutional relations chart, again, I'm sorry, this is the last beast of a slide, but I think it actually clarifies rather than confuses, are worth understanding. So we have the formal structures here, the party structures are in red, okay? And I've put the local levels down below because it should be understood whenever I'm talking about a system, the courts, the procuratorate, it's not just the top organ, but it's the whole hierarchy replicated at every level below. So these big arrows, these lovely orange arrows, I'm learning PowerPoint slowly, are who is supervised by the Supervision Commission / Discipline Inspection Commission. And you can see they go in a lot of different directions. The National People's Congress has that lovely purple arrow going down because it gets to hear reports on the work from the Discipline Inspection Commission and Supervision Commission, and it also gets to nominate and remove its top leader. The central discipline, the discipline inspection committees are obviously under party committees. And unfortunately, one thing they didn't fix is that even at the local level, the local party committee is still considered a dual supervisor of the Supervision Commission, along with the higher level Supervision Commission. So they have two levels of authority, a horizontal one. But the party one matters more here, not that it's more powerful, but because it makes it harder to do meaningful anti-corruption work. I should also say that if you look at the leadership across the levels, at the national and central level, the head of the National Supervision Commission is a deputy at the Central Discipline Inspection Community. He's a second in command there. But at the lower levels, they're the same guy usually. Unfortunately, it probably usually is Guy because of the way these things work. So we have these conflicts where the National People's Congress is supposed to be supervising the new Supervision Commission, but the Supervision Commission is also supervising and disciplining the National People's Congress, including delegates. So what does supervising mean? Right? That's sort of at the heart of it all. It's threefold, really. The first step is prevention. And this involves educating people. And the quote there is from an interpretation by the supervision organs of what they're supposed to do. And you'll see that it's oversight and inspection of political character, their exercise of public power, and their ethical soundness. This is of officials' attributes. So you see already this is a political organ. Not just my characterization, but expressly described as a political organization, which means not only is it concerned with the political ramifications, but it means that it's outside of all of those protections in the criminal justice system, and it's outside of even the administrative law protections. It's a political beast of its own. Investigation is crimes and violations. So now we have that merged for full coverage. It used to be that violations and crimes were more separate, but to prosecute, we still need the procuratorate. And the dispositions that they can give involve holding the leadership accountable where lower-level staff has caused problems or had embarrassing situations, giving warnings, criticism, and sanctions. This one doesn't count as a beast of a slide, right? Getting there? Okay. So these are the sanctions. You can see on the left here are party sanctions. On the right there are new government sanctions. And this was a new law, the government sanctions for public employees that apply to not just party members, but to anybody in office or using state power. And you can see they sort of follow the same track. In addition, what's not listed here, not intuitive from the Supervision Commission government penalties, is that during a certain period for each of these offenses, the more serious, the longer the period, you can't get promotions, you can't get raises, you can't be recommended for more duties in addition to the normal penalties. Now, this pie graph, I had to include it because the work report just came out from the Supervision Commission, and this is theirs, refers to the 4 forms of discipline, which are actually from party discipline more than they are from the government sanctions, but it's all merged now. The first form is supposed to be the majority, and this is what we've called the shift from punishing the few to managing the many. The idea is these aren't punitive. This is just we're going to have a talk with you, get you back on the right track, get you fixed up in terms of ideology so that you're a good party member again. The phrase that they use, it used to be hard to explain this to people, but I think in the era of Doge, it's becoming a little more intuitive. They will send people down to various institutions and have them either stationed there or parachuted for a short time. The idea, the phrase is hong hong lian, chu chu han. They want everybody red in the face and sweating all the time. You're nervous. The discipline inspection committee is going to come for you. I think in the U.S. context, we just talk about making them miserable so they want to quit. But it is a little more intuitive now. So that's Form 1. And you can see it's not a small number of people affected. It's over 1 million people there, right? The second form is light sanctions and organizational readjustment. Switch your position around, maybe a little bit of a move. Third is major, and the fourth is criminal. And you can see that it is shifting to a managing everybody. Now, this matters to me because it means you're managing people who haven't necessarily done anything wrong, aren't party members, but you're really managing them with party discipline. This is an ideological test. Remember, political character is right up there in the mission statement. Briefly, just to show you what levels are investigated, this is in the work report as well. You can see that village level and enterprise are the majority of people investigated. I spelled ordinary wrong, excuse me. Ordinary officials, township level, and very small numbers of leadership, but you hear about the leadership ones because they're more visible, and of course there's fewer of them, so there's going to be less. The industry breakout, it doesn't equal 100% because this is just a few industries they wanted to show us were prominently targeted. The investigation powers, coming from a criminal law perspective, were what interested me. because you can see, and the whole purpose of this slide, so it's not a beast, is to show that they're largely the same. The Supervision Commission / Discipline Inspection Commission largely has the same powers of investigation as the procuratorate used to under the criminal procedure law. In fact, it's now close enough that they try to make it so that the evidence is going to be admissible in the criminal prosecution, and that's allowed. They're trying to keep it unified. But not all of the protections got transplanted. Many of them did, like authorization to use a wiretap. It requires largely the same internal procedures. But of course, we're missing the accountability of a criminal justice system. Even in China, you have the police, the procuratorate, and the courts. The Gongjianfa are mutually restricting and cooperating. In the supervision system, it's just the supervision and party discipline system. You lose that check. Plus, you lose some really key protections like access to an attorney. Your rights to an appeal are limited. They do notably have detention. It was announced that shuangui, that indefinite sort of secret detention that nobody would know where you're taken, had been abolished, but shuangui is dead, long live shuangui. It was resurrected as liuzhi, or retention in custody, where you can be held for 3 months, extendable to 3 months, if you're suspected not just of a crime, but also of a serious violation. Now, I want to tell you that the government officials' punishments law lists the conduct you can be punished for, and we know from interpretations what a serious violation is. It's something where you could be punished by up to a dismissal from a post. It includes things that you wouldn't call corruption, including criticizing the party, including participating in a protest, including writing something critical of party policies. You could receive a sanction that could get you into liuzhi. The supervision commissions are responsible for investigating 101 different charges. It's a lot of work for them. They're lucky they took all the procurators. You'll see some of them are directly about anti-corruption, embezzlement and bribery, and they sort of decreasingly go down. These are the broad categories of crimes, not the individual charges. They increasingly get further, down to major at-fault accidents. That's where you should have put some safety provisions in at a state-owned factory or something. Something horrible goes wrong, and it's embarrassing. To me, what these offenses all have in common, these are abuse of power, is their key thing, but they're things that the party doesn't want the public to see until they can say, we fixed it. Right? So the Discipline Inspection Committee is for party matters. We're fixing this problem, and then we can tell the public. And then it'll go through the criminal justice system with its protections. I should say also that there's still overlap, which creates some level of conflict, where the procuratorate is still responsible for 14 crimes that overlap here, and the public security, but the police, are still involved whenever it's not an official who commits one of these crimes. So what is the procuratorate doing now in terms of criminal prosecutions? The purple here reflects how many cases were transferred to them after handling by the Discipline Inspection Commission, okay, by the Supervision Commission. The blue line is how many they then prosecuted. It's interesting that those aren't the same size. That means the procuratorate sometimes is getting past something and told, we think this is a crime, and usually because the person's been held in liuzhi, retention in custody, they already have a confession, they already have evidence, but the procuratorate is still not going after everyone. This is an interesting thing that needs to be researched more. In fact, they have some non-prosecutions where they actually make an official decision to not prosecute. Not just they didn't prosecute it, but they decided not to. actively. And they can impose conditions on that to put some level of restriction on people. And the final, in the first ones here, the final number there is when they sent it back to the Supervision Commission, which is something they do with police a lot in the Procuratorate, saying, we need more evidence. This isn't enough for us to prosecute. You've got to supplement this. Recently, they've started doing more of that themselves instead of sending it back. But if you think about the power dynamics, it's really interesting that they're still sort of pushing back. They are saying, listen, this doesn't rise to rule of law standards. We need a little bit more. I want to draw attention to that green column there, which isn't labeled on the chart. And I put that there just to give you another interesting data point. In the last 2 annual reports from the Supervision Commission, they've told us how many people were placed in retention and custody. That's what those green bars are. Notice how much taller they are than the number of people then sent to the Procuratorate. A lot of people who are not committing crimes, so maybe they're committing violations, or maybe they're found ultimately to have not done anything, and they get sent out. I'll wrap up by coming back to where we started. Hopefully, it's fairly clear this is not just about corruption. It's explicitly not just about corruption. The ball is not being hidden here. The not mainly a law story is a harder point, because there is law for the Supervision Commission. They've codified the political authority. And is that different? Does that make a difference? Well, we've talked a little bit about the accountability, right? That by taking it out of the criminal justice system, you lose accountability. And even if you write a law saying they shall not be accountable, that's pretty thin law. You've codified arbitrariness or codified political power. One of the reasons that China has worked so hard on its law, whether you want to call it rule of law, rule by law, but these reforms that I've worked hard on with my Chinese colleagues who've worked, sometimes dangerously hard on trying to make a better judicial independence, better access for defense attorneys. And China has responded by writing down all this law, it adds to legitimacy, right? You have the rule written down. The state can point, this is where the authority comes from, and it matters. The question is the legitimacy given by this kind of law, where it's just writing down the non-accountability, too thin to matter? Is it so thin a law that by just saying these people have this power, carte blanche, to investigate these crimes? Does transforming Shuangui into something which had no legal basis into retention and custody, which has a legal basis, make it more legitimate in people's minds? And this is not actually an easy question. It's one of those above my pay grade questions, but it gives me thought. And the other thought to have there is a debate that we frequently have. Is no law worse than bad law? So here we've codified some, I'm going to go ahead and call them bad powers. Retention and custody allows too much arbitrariness. But was it better to have it extra legal, or is it better here in terms of combating it, in terms of legitimacy, and in terms of controlling state power? And I'll stop there and let Bill have a chance to talk.
Thank you all. I want to thank Dinda and Gore for organizing this. Very good of you. And I want to thank Jeremy for coming all the way from Michigan or New Haven, or both?
Today,
yeah.
Ann Arbor, yeah.
Thank you. Thank you very much. So first I want to start with a few words about Jeremy. I think Dinda did capture it well, but I want to underscore this. So on a range of really hard topics about China, social credit, Xinjiang, all the criminal things we've heard about today, it seems to me he's been he's so humble and self-deprecating. He's been an incredibly important voice. And why is that? It's because in his writing, He consistently is thoughtful, honest, hard-hitting where he needs to be, but always factually based, always deeply substantive, never gratuitously harsh, not ideological. He's very much, as you heard, he's truly the honest broker. And so that for me as an academic in this field is just enormously important. It's an area where, as many of you probably know, it's just too much. Everything is black or white, everything's the black box, et cetera, et cetera. So I think it's really enormous service, not just to academia, but to understanding China and its complexity. Also want to thank Jeremy for the China Law Translate. I mean, the whole idea is a great idea. You know, let's collaborate. It's kind of a strange word in academia, but it's just great. And so what you heard today is very much in keeping with this. So I have a few comments. I did write these before he spoke, so you'll hear some overlap, but not complete overlap, and it's good. I don't think we disagree about too much. He knows a lot more than I do. He understands a lot more than I do, but I don't think we're going to be at too much of a point of departure. So the Central Commission for Disciplinary Inspection. So I have long thought for years and years and years that it is far more important than generally recognized outside of China. That the PRC may some time ago have departed from some of the principles of being a Marxist society, but it has not departed from principles of being a Leninist society as a sort of organizing manual. And if you grant that, and I think the evidence really shows that, that means party discipline becomes extremely important, and it means the people who oversee party discipline have a major role, and I assume that's why Gore wanted to do this session. So I first want to offer 3 observations about party discipline, and I'll talk about the National Supervision Commission, and then close with a few broader remarks about what all this suggests about the legal system. So I think the rules and procedures, organization of party discipline, 3 observations. So first, as Jeremy suggested, the rules are sweeping, and they really cover much more than malfeasance. When I ask my students to read samples of party disciplinary rules, it's to see in part that we're talking about more than malfeasance, more than a crime, a major crime, that they address issues of competence, issues of loyalty up the chain, issues of ideology to some degree, issues of broad ethics, even if they're not going to amount to a crime. In some ways, you know, being the academic out of touch with reality, it reminds me of reading the Qing Dynasty Code, where there are divisions between what's called malfeasance and misfeasance, between a private offense, 私, and a public offense, 公, and it's actually worse to commit the private offense, being unethical, being criminal, but what we might think of as innocent mistakes, screw-ups, misfeasance could also be punished. The officials of the state are supposed to get it right, and I think the same is true for the party state. So if you were an American lawyer only focusing on the criminal aspect, you'd miss some very central things. So for example, one of the many problems when the pandemic broke out is 2019, the party issued internally for party discipline a rule about, I don't remember the exact wording, but reporting major incidents up and awaiting instructions down. And part of the delay in responding in a timely fashion to the pandemic was, in effect, they didn't want to take action for, among other things, fear of transgressing that. Secondly, as Jeremy has mentioned, Shuanggui, supposedly now over, although really kind of reborn, you know, in some ways, my sense of it in previous days was it could be more severe, as you said, than the criminal justice process because it lacked the protections that Jeremy's described for us of the criminal justice process. Yes, the criminal justice process is imperfect, but, and I'm not equating that of China with other states, but my views, I tell my students, is criminal justice in any country is sort of the worst, the underside, where guarantees of law are tested. But in the Shuanggui, in the party disciplinary process, you didn't even get those benefits. You could be held for a long and interminable time, your family not contacted, not access to a lawyer, and so forth. And as Jeremy suggested, part of that purpose was to keep internal and solve internally problems. The party, be able to present a couple of things, able to present a more positive face to society, but also cleaning up its own acts as well. Third point, and this would warrant more exploration, but I've often thought in earlier years, maybe when there was a little less of an effort of the procurators and young judges to promote rule of law, I thought at times, well, the party, when people say China is lawless and the party doesn't care, well, no, the party actually internally has some pretty strict rules and with punishments that might be in their own way as severe as those of the state. So it wasn't that it was disregarding law totally. Okay, the National Supervision Commission. So 4 points here. I'll try to be brief so we have time for questions. So I totally agree with Jeremy. In 2018, when the amendments came to the Constitution, I was saying to people, these are as important as the end of term limits, right? Term limits. Eventually, President Xi will retire, or as all mortals pass from Earth, but this intertwining more and more of party and state is going to be very hard to unwind as a bureaucratic matter, as a human matter, as a personnel matter. So incredibly important. It also tells us something about the shifts over time of the party-state relationship. I think many people in the U.S. would think, well, it's always there, it's always in the background. Yeah, but in the days of the 90s when they talked about Daum, Zheng, Fengkai, dividing the party from the state, people wouldn't be explicit, and now it's right out there, right? I mean, you get academics like Jiang Shigong or Zhu Suli in the law field, and it's not like it's something they want to hide. They say, hey, this is how it is. You get name cards, and people, instead of just saying they're a professor, indicate that they may be a party official as well. And if you looked at the current website of the Party Disciplinary Commission, you would see, I should have brought along, on the one hand, same page, right, is the symbol of the Disciplinary Commission, and the other side of the same page, the symbol of the Supervision Commission. I mean, it's not like it's a bug, it's central, and they're not shy about saying that. Third, I won't belabor this point because Jeremy has said it, but the potential sweep now beyond simply party members. So he very nicely laid all this out. And I would simply add to that recently had a visitor from PRC, very thoughtful, smart law professor, and he said it kind of creates a specter. You sort of now know it's there in the background, even if you're not a party member. So it wasn't that there were perfect protections under law before, far from that, but it's making people a little more looking over their shoulder. And finally, being here, the historical touch, creation, although as he spelled out so well, the National Supervision Commission has a sort of odd status. In some ways, it's reminiscent to me of the idea of a censorate in imperial China and of a control yuan during the Republican China era. And as he illustrated, it complicates a lot, even sort of interactions among different state entities in the sense of, who's responsible for what? Is it the bureaucracy? Is it the other organs of state justice? It really messes up the picture in some ways. So let me close with a few comments about, actually I have a few more comments than a few, but I'll try to be quick, about the legal system more generally. I personally, one reason I like what Jeremy does so well is I find at least in the American writing about Chinese law, the turn from law, that some people say, well, China, Carl Minzner and others, China's turned away from law, and the opposite view, the so-called turn to law, Zhang Taitsu at Yale and Tom Ginsburg. I find that debate too black and white and a little too sterile in a couple of kinds of ways that I want to very briefly speak of. And I guess I would say the same about another, maybe the other major debate among Western scholars. Is China a dual state or not? So there's a German scholar many years ago, not writing about China, who said, well, he was writing about Nazi Germany, I think. He said, well, you have the normal day-to-day actions of law and that aren't political issues, and then you understand that an authoritarian government, the explicitly political that tests the regime is always going to be handled differently, what he calls prerogative state. So that's been applied by several people, some of them very serious, to China. But I also find that, again, too leaden, too binary, too black and white, too much cardboard. So what do I mean by all this? So Jeremy has showed through his work with Procuracy and others that the turn to law, turn against law, there's more law developing, and the commitments of some of the people who are involved in doing that, creating it and staffing it, they're complicated, right? The Procuracy lost a lot of its authority to this new entity Jeremy's told us about. And, is it that nobody likes to give up institutional power? Is it that some of these people are seriously trained professionally and have a sense of integrity and professional identity? I suspect it's all of the above. So I kind of think the turn to, turn against law thing, it doesn't quite capture it. It also fails to capture, this is a little beyond our immediate topic, that when faced with crisis, as with the pandemic, the party may have lots of elaborate rules about how to handle, the state, about how to handle a pandemic, but then they end up mobilizing in the mode of an old-style political campaign because they're sort of panicking. Last couple of quick comments here. The dual state idea also doesn't quite work because, as he was sort of suggesting, the wall between what's political and what's not political, and between what's strictly legal and what's a political offense is increasingly it seems to me, getting blurred with stuff of the type he talked about today. And I could give you, I won't waste your time, many further examples of that. So, for example, if the state is, as we see, so heavily involved not only with SOEs, but with private enterprise. Think of President Xi's meeting with Ma Yun and others a week or two ago. Where does one draw the line between so-called prerogative, political, and normative, that is routine, everyday things? If there's a case involving one of those major companies, I'm not at least impugning the integrity of the courts and the individuals there, but surely the endorsement now by President Xi sends a message to regulators and others. Now, in saying all this, I have to be humble and realistic also about how our own legal system faces many challenges these days. So I had a little more, but I think I will stop and simply conclude my maybe just one or two, get me talking, I can't stop, right? One or two last things. It poses all this, what Jeremy told us, what I've mentioned, I think poses for the leadership of a party that's concerned with the legal system some real dilemmas of the very type he mentioned at the very end. And that is, in some ways, I think they're trying to have the benefit of law without some of the costs or constraints of law, right? So can you create a system where you, in fact, have legalized, as he suggested, things that might be in part arbitrary, put a label of law on it? I guess I would raise the question, without meaning to be cynical, it's kind of hard at the end of the day to have it both ways. You sort of, if you will, cheapen the strength of law, the integrity of law. The idea of law is ultimately going to have some separation from politics, and it has to have some predictability. If you're labeling things that, almost by definition, as you said, will have more of a political salience, that are going to end up being more politically driven or arbitrary. It's very hard to have it both ways. This is not a problem unique to China, right? Sadly, we're seeing, some things even here. That might raise that problem. But it's a real dilemma for the party. If you want the courts, for example, to serve the purpose that I think the party, in part, at least intends, and that is a place where people with real disputes can bring them, channel into a peaceful resolution through a court instead of have it out in the streets as political. If you want foreign investors to come and put their money in because they think there'll be some resolution in a fair manner, ultimately beyond politics or guanxi, then you really have to give it some autonomy. You have to give it some integrity. And when you mesh things in the manner that he's describing, you're risking achieving that goal, right? You know, at the end of the day, you're not sort of, people will understand that. People will recognize that. And so you diminish some of the very value of what you're trying to create. Anyway, just thank Jeremy again. I think it's great that he's come up to share his wisdom with us. And maybe we can open up in the remainder for questions for you.
That'd be great, yeah.
I'm one of the visiting fellows at the Fairbanks Center, and just had a curious question for you about the historical precedent for some of these blurred lines. I mean, doesn't it go back to the Qin and the Han Dynasty? And this isn't a new thing, right? And clearly, the whole idea of rule by law, which is a tool of the state, versus rule of law, which is above. I mean, isn't there a lot of precedent for this? Is there a reason for this, other than the precedent that's already, you know, existed for thousands of years? Thank you.
It's a great question, and I'm not the historian, but yes, I mean, this has existed. You were mentioning the Qing Code, but even beyond that, people have tracked the development. But for a while, there'd been a pause in this sort of merging of party and state and this having a sort of controller. You know, it's an interesting thing. In many ways, the Supervision Commission fills the role that I used to use to describe the party as a whole. You know, people get confused by the term party because we think of a democratic system or a parliamentary system with multiple parties. And, you know, in a single party state, the party's function is really totally different. It is in many ways a separate branch of government that goes through the hierarchy, making sure people are performing their duties according to the center's wishes. And that structure has always existed, and this is in some ways a manifestation of that. There are scholars who have written quite well about tracking it all the way back. I'm trying to stay in relatively modern history, mainly because I'm a nuts and bolts sort of law person and looking at what's happening now and trying to understand it versus that. But I think there's no question that it's in Xi Jinping's administration that we've started to see this revival. You know, in response to part of what you were saying, when I was in Beijing, I remember when President Xi had first taken office, there was a lot of discussion about returning the party to a revolutionary party. We have to make it tighter and more disciplined through. And I think now it's beyond just a revolutionary party, it's a revolutionary state. And that doesn't mean every citizen has to be red in the face and sweating all the time. I don't think that's possible. You know, even with the COVID controls, we see pushback. You know, it's fairly fragile, that balance between state and citizen. But within all state actors, they want all of the people who are using state power to be tightly disciplined. You know, this has always sort of been the mentality, is the center's plans are right, but people implementing them down the line are corrupt or not following orders, and that's where the problems come from. I once had a colleague who actually gave me, in earnest, the line. He said, the party has never made a mistake. Party members have made mistakes. And, you know, well, okay, there you go. But I think there is a traditional mentality. You know, I don't think it's because of tradition, but you can certainly see historical roots of this moving forward.
I had a question, if I might. Very unscholarly, unacademic questions. One is about the procuracy. I'm really fascinated by, you know, you described that, you said these are the guys who really love rule of law. I mean, they really, you know, believe through and through in the importance of that. And I'm really curious on a human level, like what happened to those guys? Are they, and I assume it's mostly men, but, you know, I assume none of them quit, but they moved over, and are they, you know, what happened to them? That's my first question. Second thing was, I appreciate that you're both saying that it's complicated and that, that this is not a black and white thing, and that there is a huge effort to writing laws and putting even promulgating laws that are sort of, saying we don't need to be transparent or whatever, that kinds of thing. But on a kind of more human level, I'm hearing Chinese friends just saying 没有法治. There is no rule of law in China. So how do you sort of parse that? I guess that's, so those are sort of two questions.
The second one's a much bigger question. So first, in terms of the procurators, I mean, they're doing their job at the National Supervision Commission, and they do bring their expertise to it under the new powers. There are men and women doing the job who are very committed to the idea of rule of law and understand the needs for what a court's going to need, what they're going to need at the end of that, and are bringing professionalism to it. But they're doing it within this new system under the party. In terms, we can all discuss what we mean by rule of law, and we have these debates that we're all never quite clear we mean the same thing. Some people love to say rule of law versus rule by law and then act like that means something and it's pat and we all understand what it means. And we get the general idea. Rule of law meaning that the government is also constrained by the laws, that the government power is subjected to the laws and the laws can be used to challenge government action. We're seeing a lot of that in our country right now. Whereas rule by law, we sort of mean something like corporate governance. Your corporation that you work for hands you down a rule book. It's got rules. Things follow rules. If someone's not following the rule, you can point that out and say, hey. But ultimately, as with the supervision system, when I say, hey, what they're doing isn't in this pilot project isn't constitutional, well, because it's more of a rule by law system, they just amend the Constitution. Because the person is they're not constrained by the law in the same way that the citizens are. It's marching orders and rules for how things get done. And rule by law, as Bill was touching on, can accomplish a lot. It can resolve civil disputes. It can make people able to engage in transactions reliably predicting the outcome. It can do a lot. And civil cases are easier because it's not criminal where it's state power versus a citizen. It's two citizens dealing with each other. And the state's happy to resolve that in a court as opposed to the streets. Medical malpractice was a big area where people didn't trust the courts, and they were thus creating chaos in hospital waiting rooms, attacking doctors. And this was a big issue. We'd much rather that go to the court. Of course, that's an easier thing to deal with, and it gives legitimacy to the party and the party state for being able to resolve the difficulties. So what do we mean by law is, ultimately the big question. My feeling from a lot of professionals in China these days that I'm talking to, there's people committed to working towards a real rule of law, putting administrative power in a cage of laws is one of the phrases, making everything accountable and transparent. This was a big blow to that. But they also are recognizing that while the system isn't perfect, they're doing pretty okay compared to the world. And that corruption is a problem in many countries that aren't always addressing it as successfully as China, and aren't providing their citizens with as good a life. So obviously there's a huge number of complaints still out there amongst legal professionals and everybody else, but there's also a recognition that the system is delivering to some extent.
So add a really quick comment. So I don't like the rule of law, rule by law.
Meaning?
I mean, just for the reasons Jeremy said, and I urge the students not to think in those terms. So it doesn't mean you can't say some hopefully sharp, insightful things. And so the prosecutors, I wouldn't say all prosecutors in China or anywhere else are deeply committed to rule of law, right? Some prosecutors get so zealous, they may go beyond their bounds. That's one quick point. Second point, when you say rule of law, rule by law, it also means, going back to his concluding point, what's the law is the content of the law. What are the values in the content of the law? And so if the law is sort of trying to cement in what ultimately is going to be somewhat arbitrary, yeah, you might follow the law, but is that really, advancing human independence? Part of the big test is going to be, can you take on as Jeremy said, take on the authorities? I would be, I guess, a little less sanguine than you about the civil law. That goes to the binary state, the dual state. Well, on political matters, sure, we can't expect much. On routine day-to-day matters, we can expect more. There are 3 really interesting books published in the last couple of years about divorce in China. I mean, I don't know any other area in China law where there's such detailed, well-done 3 studies that came out roughly the same time by Li Ke, who's been here to speak, by He Xin, who's been here to speak, Ethan Michelson at Indiana. And one takeaway from all 3 books is this, so this is a non-political area, local people getting, ordinary people, labaixing getting a divorce. One takeaway I had, and I think it's true to what they wrote, is it's not as though the party has said, make it harder for women who feel abused to get a divorce, favor men, and it's not simply age-old sexism. It's many of the, like in Li Ke's book, judges she interviewed, they think what matters most of all to the party state stability. And then they think, what's going to cause less instability in my area? Well, if I have to decide between unhappy woman and unhappy man, unhappy woman's probably going to go home and sulk. Unhappy man might actually cause some trouble. And so they just almost instinctively favor the men, not only their own inherent gender bias or whatever, but, so the binary gets really hard. What state, what sort of removed from.
Yeah, and great example with the divorce. And I've the 3 scholars you mentioned are amazing people who've done great work. And I've written recently on domestic violence and the divorce situation as well. I have an article coming out soon. I would say, first of all, civil looks good compared to criminal. Sure. Is all I mean. But I think what we're getting to is the divide of politic and law power. And that when you have real law, bylaw of law, whatever, I don't like that distinction much either, mainly because we don't really know what it means. You have the rules to enforce. The politics is about values and whims sometimes, right? A political force can shift. And there is no issue that cannot be politicized and have the politics weigh in on one side or the other. It's also explicit now, because of the merging in the law, that the purpose of investigations, so to go back to this example, not the divorce example, the purpose is different for a discipline inspection versus a criminal or violation administrative. One is to find proof of facts. Somebody described it talking about abuses of power in each situation. If somebody uses torture in an interrogation, if it's a criminal one, it's to get a confession, to prove the crime. And a crime is a statute. If it's a party discipline, it's to get compliance and intimidation. It's a different goal. And now, torture is a strong example, but going back to those 4 forms where we're trying to manage the many, punish the few, you see the lighter side of that. That what they say explicitly in the interpretation of the supervision law is that the goal of the investigation is not to handle them like a criminal, but to give them ideological training and correction to get people back on the path. And this is a different model, right? This is a political. But the politics, even in divorce cases with the family education law, education promotion law coming out, we see that even parenting is now in that blur of politics and law.
Great.
We're over time, but I think we should do one last question from
Certainly.
a student.
It's our fault
From
for
a student, if
speaking
it's
too much.
okay.
Yes.
So,
Thank you so much. Hi, I'm a second-year PhD student at School of Education. Thank you for your very interesting and important work. My question is about your, I would say, positionality or your situation when you were working in China, especially on this very sensitive issue. you mentioned you work with legislators, probably public servants too, on this issue. I'm just wondering, like, what does your everyday research practice life look like while you're working on this topic? And also you mentioned you wish to return to China someday, and I wonder with this research, how do you plan to do this, and will this supervision commission situation also impact like your work?
Great questions. And I'm always happy to talk about my work. Because I do criminal, which includes adjacent to criminal stuff, so I do juvenile justice, which means I also have to think about schools and domestic violence and all the things that lead to juvenile delinquency. So it's a broader area. I work primarily, though, with prosecutors, police, and judges. And the way that I engage, I like to think of myself as not an expert in the Chinese system or the US system, although I have training in both, but I know just enough to be dangerous and just enough to make connections across the aisle. With the aisle being the two countries. So I bring scholars or practitioners from the US. I've brought federal judges from the US along with US assistant US attorneys, sometimes retired, sometimes still in practice if they can get permission, who to come over and do comparative trainings. So, for example, China has a new system in its criminal justice that was loosely inspired by the plea bargaining system in the US. They call it the plea leniency system, 认罪认罚. And we have brought over people who would do mock trials, where we had lawyers and a judge explaining how a plea agreement would be accepted and things like this. With police, I've brought police here and worked with police in China on domestic violence, or an area the U.S. is not known for doing very well, encounters with people who have severe mental illnesses, and talked about techniques for de-escalating. And I've brought over amazing U.S. talent who's ready to share what they've learned, the hard lessons they've learned, and really admirably, on both sides, one, the U.S. side is not afraid to show the problems with our system. I mean, nobody wants to be a missionary for the U.S. criminal justice system. You know, trust me, it's got a long ways to go. But people can learn from the mistakes as well. And the Chinese side, you know, it's sort of amazing to think that a room full, if you picture it in reverse, a room full of assistant U.S. attorneys sitting there listening to a foreigner explain their legal system is sort of unimaginable. But China has always looked abroad for inspiration and comparison when developing new law, and that's very admirable that they would allow that. I work primarily through training centers because I'm an academic with an academic institution. I'm not a traditional academic, as I say, but I am doing academic work, and that's easier for me to connect with other academics. And they have connections often with practitioners, be it lawyers or whatnot. In terms of sensitivity, everything I do is above, open. I believe in transparency, and I'm working on sharing U.S. experiences more than anything. That said, my website has been blocked in China for 8 years, and it is largely translations of Chinese law, so that's sort of disheartening. But it does have original articles, and that's what the problem became. But I, function with my colleagues, and if I'm told not to do something, I don't do it. But that's, I don't stop doing something because I'm afraid I'll be told not to.
So I want to thank both Professor Alford and Jeremy so much for joining us today. Thank you for the work that both of you do and for adding and bringing the complexity to this conversation. We really appreciate it.
Thank you so much.